Just before I move forward with what suppliers and distributors can expect in 2022, let me echo a couple of things that Veronique and Ellie touched on. It is the case, in fact I remember it very vividly, about 4 or 5 years ago, Emma and I were acting for a client. The client was in the process of parting company with its agent. And one of the issues we had to consider was the passing of WhatsApp messages between the parties. The passing of WhatsApp messages included the passing, if I remember correctly, of images that called into question whether certain criminal offences had been committed. So please, if you're going to be exchanging messages of any type, whether it's emails, whether it is WhatsApp messages, whether it's text, anything at all, with other parties, do be aware that ultimately they can see the light of day and have consequences. And the other thing, just to touch very briefly on it, I echo very much what Ellie and Veronique have said. Please never do an Enron. In the United States, the destruction of documents by Enron ultimately led to the end of Arthur Andersen in the United States. And we don't want the same sort of thing ever to happen to any of you. So please don't do an Enron. Right, we come to the art of the possible. The art of the possible. Why? It is the case that there are various things that various parties would like to do, whether we're talking price stability, which is arguably a euphemism for resale price maintenance, restricting territories in which third parties can sell, dual pricing, having one price for goods going into store, one price for goods going online, restricting the use of marketplaces and platforms. One thinks of Amazon. All of these are issues that we come across because we're asked to look at them, or whether it's for brands that we act for, whether it's for third parties acting for brands. And it is the art of the possible. Why? Because ultimately, whether clients choose to be bound by what the law says, or whether they say, well, we can possibly get away with it, is an issue for them. Within the law, we talk, as lawyers do, about hardcore and softcore restrictions. I may use those terms going forward. Hardcore restrictions, if there is something that is a hardcore restriction and you do put that sort of restriction in your agreement, or perhaps seek to impose it outside of the agreement, then there are going to be consequences. The agreement is going to come to an end. Softcore restrictions, softcore is when the restriction itself fails but the agreement nevertheless continues. So that's a bit of a spoiler alert, but why the need to comply with competition law or UK and EU competition law at all? Well, it's because if you don't and you cross the line and your restrictions mean that you are infringing UK or EU competition law, there will be consequences. The agreement itself can be ended, just ends. There can be consequences in terms of third parties claiming damages against you. There can be consequences under English law of penalties being imposed on directors and senior managers involved in the infringement. Those penalties can be monetary, they can also be penal, and we have seen directors and senior managers be imprisoned as a result of infringing competition law, as well as, in the case of directors, being banned from being directors for a period of time after the offence has been committed. And both under EU and UK competition law, fines can be imposed, whether it's by the EU Commission or whether it's by the UK's Competition and Markets Authority. So there is a need to comply. That need exists today. It's going to exist in the future. But, in the words of Bob Dylan, the law, it is a changin'. And the law, it is a changin' because the current law that we have, so far as the UK is concerned, which is a mixture of EU law and UK competition law, that is in existence now through to 31 May 2022. On 1 June 2022, we will have new law. It's changing because of Brexit. It's changing because of the decisions that were taken in 2016 and since then, with the result that we have a somewhat strange situation that the law that existed up until January of last year is called EU retained law, and that continues to apply so far as the UK is concerned. And the current EU competition law is part of that retained law. So that will continue through to 31 May 2022. We have the law, it is changing because there are different channels to market. When the existing EU competition law was drafted back in plus minus 2010, we didn't have, or certainly we didn't have to the same degree as we have today, the use of third-party platforms. Amazon, yes, it was a force in the marketplace, but it was nothing as it is today. So there have been changes in the channels to market. The law, it is changing. And we have also a recognition by the competition authorities, by the EU Commission and by the CMA in the UK, that there can be vertical supply chains which cross over into what are effectively horizontal agreements. So a vertical supply chain typically in the classical sense would involve a manufacturer selling to a wholesaler who sells to a retailer who sells to a consumer. But now we see manufacturers selling direct to consumers, but also selling on to wholesalers who will perhaps also sell direct to consumers, as well as selling to retailers who definitely will sell to consumers. And where there is the same parties selling to the same base customer, whether it is at the wholesale, retail or consumer end, we're into horizontal agreement territory. And given that EU and UK competition law in this area is primarily concerned with vertical agreements, there's a bit of a mismatch, which both the EU Commission and the CMA have had to come to terms with. So let's just touch very briefly in the next slide about exclusive distribution and selective distribution. Exclusive distribution is my appointing Emma and Emma being able to sell my products within a given territory to the exclusion, note the words, of all others. Is there a law that actually says that? Well, not quite. And therefore, as lawyers, we invariably look at other words in the agreement which may or may not detract from the exclusivity which I have granted to Emma. That's the current position. But what we see is that the European Commission is now talking in the notes that have been published by the EU Commission about there being a limited number of exclusive distributors, which calls into question how you can have a limited number of exclusive distributors given the very meaning of the word exclusivity. Part of my darker thoughts will probably say that this is almost akin to the announcement made about a year ago by, I think, the then Northern Ireland Secretary, who, when the UK Parliament was considering the UK Internal Markets Bill, as was talking about the bill breaching the agreement which had been reached with the EU in a specific and limited way. So we'll have a limited number of exclusive distributors. But what's the CMA's position on that? We don't actually know at the present time. Are they edging towards that? Not sure. And what about passing restrictions down the supply chain? The EU Commission seems to be fine going forwards, come 1 June 2022, that will be possible. I know for a fact, given some of the requests we've had over the last few months from our clients, that they're going to actually be very appreciative of the ability to pass restrictions down the supply chain. Again, the CMA's position is up in the air at the moment. What about selective distribution? Well, selective distribution is where goods are supplied on the basis that if a particular party, the next level down in the supply chain, is able to meet certain objective criteria, then they are able to be admitted or are required to be admitted to the club. in order to be a distributor of that particular product. Selective distribution is effectively an escape mechanism for certain products or certain goods, certain brands, from the restrictions that would otherwise be required by EU and UK competition law. What I think we're going to see is a movement there as well, which is going to help brands, but we shall see. So if I can move you on, please, then to the next slide. And I'm going to talk about online sales restrictions. And it is the case that both the CMA, the Competition and Markets Authority, and the European Commission are contemplating a relaxation of the treatment of online sales restrictions. So where previously online sales restrictions were regarded as hardcore, were regarded as if you put them into your agreements, there would be a problem, there would be an infringement of competition law, it looks as if they're going to be allowed in very broad terms. And why? Because the online channel has now become so well established, arguably so well established, as we'll see in a moment, that the in-store channel needs to be protected. And in terms of protection, well, part of that protection comes in the form of the concept of dual pricing. And I think where we are is that the EU Commission is now taking the view that provided dual pricing rewards an appropriate level of investment, there can be one price for in-store and one price for online. Certainly the CMA sees no problem with this at all, and I think where we will end up is that the EU Commission will be in the same position itself. And similarly, the Commission and the CMA take a view that different criteria can be used outside of the pricing concept. Different criteria can be used for both in-store and online sales as from 1 June. What about restricting use of price comparison or paid referencing? That for the EU Commission will be a problem. It will still be a hardcore restriction. The CMA, still to express a view. What about restriction of different languages? The EU Commission's position is that if translating a website into a language not commonly used in the country of the distributor, that is active selling. You're going after a particular market because you translated the website language into a language which is not used in that territory. Active selling can be restricted, so hopefully we will find that that is okay, and the CMA, well, the CMA is a bit behind the EU Commission and still to express a view on that. And different online sales strategies, the EU Commission again is okay. The CMA is going to be publishing further guidance as to whether it's going to treat this, having different online sales strategies, as active selling or passive selling. The difference being that a restriction on active selling is a prohibition, can be prohibited. A restriction on passive selling is going to be an infringement of competition law. And we also come here to the interaction of the concept of the horizontal agreements. If you're selling yourself online to a particular customer base, for example consumers, and you allow the next person down, the wholesaler for example, to sell online to consumers, then that is effectively a horizontal agreement. And as I said before, the law that we have in this area, which is concerned with vertical supply chains, has the difficulty in coming to terms with horizontal agreements. We'll talk a little bit more about that in a short while, but if I can move you on to the concept of dual distribution on the next slide. Dual distribution, if we take the example of where the manufacturer both wholesales and retails a brand, that is dual distribution. The Commission at the moment is saying that where there is a market share of 10% or less, then there can be dual distribution and there will be no question, there won't be any infringement of competition law. The difficulty that lawyers have with that concept of 10% market share is, well, how do we know what the relevant market is? So, if for example, we're talking about watches, is the relevant market all watches? Is it watches of a particular type, for example, sports watches? Is it watches at a particular price point? What is the relevant market? And that is always an issue for lawyers in this area. But what is of concern to the Commission is where we move above the 10% market share up to 30%, and there is the exchange of information between the parties who are parties to that agreement. It could almost be said, given the news at the weekend, that Et2 JD Sports, given what perhaps happened or didn't happen in a car park near Bury. And then we come to the CMA's view, and the CMA says, well, if there's going to be exchanging information, We're actually quite relaxed about that. It's quite a divergence from the way the European Commission is looking at things. And at the moment, the CMA is saying is we're not going to worry if it's 10%, not 10%, whether it's 25%. What we're concerned about is giving the parties the right to undertake their own assessment. So there's going to be self-assessment as to whether or not the agreement that you have entered into for the purposes of dual distribution does cause a problem or doesn't cause a problem. And the issue, the danger with self-assessment is that you get it wrong. That's the danger. The bigger danger for us as lawyers is that we get it wrong. But hey, someone's got to take the risk. So we have there the interaction of horizontal agreements again, and we have there the problems that arise because what we're talking about is a vertical law trying to interact with a horizontal situation. If I can move you on to MFNs, most favoured nation clauses. Most favoured nation clauses arise so far as the online channel is concerned. Parties are concerned that if they're going to be offering your goods for sale, that you're not going to give a better deal to someone else, to one of their competitors. The CMA is looking to distinguish between a narrow most favoured nation clauses from what it calls are wide most favoured nation clauses. And I hope after this session that you're not going to ask me to try and distinguish between the two. What is the position, however, is that at the moment the Competition and Markets Authority believes that narrow most favoured nation clauses can be allowed, whereas with wide most favoured nation clauses the CMA takes the view that these should be hardcore restrictions. If you put them into your agreement, the agreement itself will fail. So, that's the position of the CMA. It is taking, again, a divergent view from the European Commission. And the European Commission, well, we will see where we end up. As I said before, the European Commission is further down the road in terms of where it wants to be, so far as 1 June next year is concerned. And it will be a case of whether the CMA is able to play catch-up. So let me turn now to the final slide, which is the slide of take-home points. So there is still time for change. To adopt the words of, I think, Michel Barnier a couple of years ago, nothing is agreed until everything is agreed. So far as there is still time to change, point 2. Well, what we are seeing, and we have seen certainly during the course of this autumn, is increasing, what I can only describe as increasing political interference with the workings of competition law. We've seen that recently in the supply of carbon dioxide, where competition law has been suspended. Previously we saw that in respect of the supply of motor fuel, petrol, diesel, where again where competition law was suspended. The CMA, the decision by the government, I think it was last year, not to allow an extension of competition law, which was being sought by the then Director General of the CMA, led to his resignation. But the point that I think is really material here is what is going to happen. We're going to be in a situation come the end of May next year that the old law effectively has stopped. It's in a form of suspense, because there will be a transition period to allow for a change from the old law, where the agreements hopefully comply with the old law, to where they will comply with the new law. But for those of you who are in existing agreements, and those agreements do comply with the law as it is, do you stick and be in a situation where perhaps you don't take advantages of what the new law has to offer you, depending on the opportunities which the new law has to offer you? Do you seek to engage in variation? Variation itself, it has to be a consensual process. Both you and the other party to the agreement have to agree on it. Do you terminate the agreement and seek to put in place a new agreement? You can do that, but again, there are risks involved, because your counterparty may say, well, you haven't terminated the agreement in accordance with its terms. Here's my claim for damages. In the concept of the agency relationship, here's my claim for compensation. Or you may find yourself that you terminate the agreement, hoping to put in place an agreement which does take advantage of the opportunities offered by the new laws, and find that your counterparty doesn't want to enter into a new agreement with you. Be careful again what you wish for. And then we come to two further issues which will, I'm sure, cause problems. And I say that not because I would like them to cause problems, but because of what they are. It is the case that for many businesses, they will operate in the UK and they will operate in the European Union. Those businesses will have to comply with two sets of laws which will differ in some respects. Of that, I'm pretty confident. The CMA and the EU Commission are too far down their process in the new laws that will come into force come 1 June next year, that there will not be differences between them. And businesses operating in the UK and in the EU will have to comply with two different sets of laws. And for those businesses trading in Northern Ireland, good luck. Really good luck. We don't know yet what is going to happen so far as the Northern Ireland Protocol is concerned. We don't know if there's going to be a change to the Northern Ireland Protocol. We don't know if there's going to be an invoking by the UK government of Article 16. We are in a bit of a mess so far as Northern Ireland is concerned, but where there is a mess, there will also be opportunities for business, and so who knows where Northern Ireland itself will end up. And with that, on that happy note, I'll close the formal part of the session, but please join me in thanking our speakers.